guys to like, share, comment, and follow. So guys, the Citizens Coalition for Change at CCC, they said it ditched its plans to approach the courts to challenge the electoral theft, mainly because the Zimbabwean judiciary is fully and faithfully captured. The opposition party led by Nelson Chamisa has rejected the results of the August 2023 elections. They've cited various irregularities mentioned in observer missions reports, such as flaws in the delimitation process, delayed release of the voters' roll for candidate auditing, restrictive fees for accessing the voters' roll, disruption of opposition rallies, the unconstitutionality of the patriotic bill limiting freedom of speech, disqualification of presidential aspirants, raised nomination fees, inadequate progress in achieving gender parity, concerns about the independence of the judiciary, allegations of voter intimidation, controversies around postal voting, and bias of state-owned media against opposition parties. So here's the statement from CCC why they ditched the court route to challenge the electoral theft. And in Article 11.7, one of the SADC principles and guidelines governing democratic elections reads 11.7.1. During the post-election period, the COM shall observe the conduct of procedures and processes concerning electoral complaints and challenges by citizens, prospective voters, and those seeking election, including the provision of effective remedies for violations of electoral-related rights. This principle is that domestic remedies available in terms of the laws of a member country must be effectual. An aggrieved party who can show that domestic remedies are not effectual is not obliged to exhaust them. Domestic remedies present themselves largely in the availability of judicial remedies. It is those that must be evaluated before a party can be required to exhaust them. In the case of Zimbabwe, those remedies are not available at all. The Zimbabwean judiciary is fully and faithfully captured. Infamously, Emmerson Mnangagwa has bragged that he is the army, the police, and the judiciary, a claim typified by the continued incarceration of Citizens Coalition for Change CCC senior official Job Scala on trumped-up political charges which were meant to exclude him from the elections. Indeed, one of the CCC candidates, Godwin Hakata, won the National Assembly elections while in prison, having been arrested for taking part in a car procession on his way to a sanctioned rally. Zimbabwe lacks a functional separation of powers. The executive fully controls the judiciary, and that has been enabled by a skewed appointment system in terms of which Mnangagwa has staffed the courts with his sympathizers. Through Zimbabwe as a public interview system that preserves the appointment of judges, it is an open secret that the results of those interviews have been religiously ignored. This lack of separation of powers has led to the politicization of judicial institutions. Various judgments that have come out of the courts show beyond any doubt that the judiciary is disposed towards Mnangagwa and does not consider itself bound to the constitutional ideal of independence. For this reason, even judges whose behavior have been errant have, upon pledging loyalty to Mnangagwa, been spared from giving account. A case in point is that of Justice Chinamora, whom the Judiciary Service Commission recommended must face a tribunal arising out of clear misconduct. Through Mnangagwa's constitutionally enjoined to appoint such tribunal, he has not done so to date. Going into the elections, Justice Chinamora had more than 10 electoral challenges found in all against their challengers, and is definitely paying back Mnangagwa for his decision to protect him. In that regard, it must also be noted that the Chief Justice designated all High Court judges as Electoral Court judges, but only a handful, being not more than 5 judges, had matters in the Electoral Court. The following, however, puts beyond any doubt the fact that no judicial remedies are available to the CCC in the aftermath of the disputed non-election of the 23rd August 2023. the Chief Justice. In terms of the Constitution of Zimbabwe 2013, Chief Justice Luke Malaba ought to have retired on the 15th of May 2021 when he turned 70 years, in a bid to ensure that he would be available to deal with any electoral disputes in 2023, having come to his aid in 2018. Mnangagwa unlawfully amended the constitution and extended Malaba's retirement age to 75, the first time a war constitution was amended to accommodate one person and a judge at that. The extension was a fool's errand because in terms of the constitution, any extension of a term limit must not benefit the incumbent. The matter was litigated upon the High Court by 3 judges, all of whom have now been victimized in various ways, held that Malaba's term could not be extended and he was obligated to proceed on retirement. Mnangagwa's government was incensed and responded through the Minister of Justice in contempt of court and issued various threats to those and other judges. In a bid to rescue Malaba, Mnangagwa and a third party bring litigation before the Constitutional Court, which sought to nullify the judgment of the High Court. This notwithstanding that Malaba and his fellow judges who had been cited in the litigation had appealed to the Supreme Court, notwithstanding that the Constitutional Court judges were cited in the litigation and had exercised their right of appeal. They sat as a court in a matter in which they were interested and nullified the judgment of the High Court. As a result of this judgment, Malaba is continued in office. In the run-up to elections, Malaba issued orders in chambers in the Kasukwere matter without hearing parties. He solely dismissed applications that could only be dealt with by 7 judges. He has shamelessly played the part for which he was hired. In any petition, Malaba would be the one to sit in judgment. He has already played his hand in a manner consistent with the unlawful extension of his tenure. It is inconceivable that having had his tenure extended by Mnangagwa under these unlawful circumstances, he could turn against him in the most crucial matter of Mnangagwa's political career. As it happens, a few months before elections, Malaba was the first to receive undue gifts from Mnangagwa's administrations in the form of an ex gratia payment of close to $500,000. This is in direct breach of the principle of the independence of the judiciary, that the gift was received straight from Mnangagwa's Minister of Finance and not from the Judicial Service Commission. Does make a bad situation worse. One of the judges who wrote the Constitutional Court judgment, which nullified the High Court judgment, which had found that neither Malaba nor any of the Constitutional Court judges could benefit from the extension of tenure, was Bharat Patel. 7 months after writing the judgment, Patel became its first beneficiary and had his tenure also extended by Mnangagwa. He continued to sit on the Constitutional Court bench and is one of the judges who must hear the presidential petition in the event of it being filed. Patel, just like Malaba, had his tenure extended for purposes of the 2023 electoral litigation. Just a couple of months before August 23, all judges of the Constitutional Court received an extra gratia payment from Mnangagwa's Minister of Finance. They received $400,000. These payments are not part of their conditions of service. The payments are not loans. No agreements of whatever nature were signed by them, and the nature of the arrangement has been left deliberately fluid. These are bribes, and the fact that they were received some few months before the elections is telling. This matter has been raised in Parliament by Themba Mliswa, then an independent member. Now, all these judges are expected to sit in judgment and deal with a matter that affects their benefactor, who recently gave them undue gifts. As it happens, 5 of these judges also received payment from Nedbank in 2018 after the presidential petition hearing. These payments were also never part of their conditions of service and have to this very day not been declared. Leading to August 23, A lot of litigation bearing on the conduct of free, fair, and credible elections was brought. All the matters bar one, the ballot cove, and even then an appeal, and after a massive pushback, produced bogus judgments. As far as the Constitutional Court is concerned, it was predominantly seized with the Kasukwere matters, which were all resolved on bogus grounds. These challenges brought are key because they speak to some of the matters that must be of a necessity be raised in any petition. A brief rundown of some of the matters is imperative. Markham versus Zeg. This matter was brought by an opposition parliamentarian who enforced his right to a voter's roll. The application was dismissed, although the Electoral Act Chapter 2.13 makes clear that any Zimbabwean is entitled to a copy of the voter's roll. The voter's roll that was used in the elections was not given to candidates. Monzora versus Zeg. This is a matter brought by one of the opposition leaders in which he challenged the delimitation exercise. The application was dismissed, although all the political parties concerned accepted that the delimitation exercise was unlawful. In dismissing the application, the court did not say the delimitation exercise was lawful. Statutory instruments and amendments to electoral laws. The Mnangagwa administration sought to amend the constitution through a statutory instrument after the proclamation of the election dates. Two issues arose. First, a statutory instrument could not amend the constitution. Second, no law could be amended for purposes of elections once an election was proclaimed. Notwithstanding its clear merit, one of these applications failed and other is yet to be determined. Next was the security contaminant case on ring fencing Zarasekwa barracks. It too failed. Mnangagwa versus Kasukwere. This is a case brought by a ZANU-PF activist which sought to bar a presidential candidate from contesting in the elections. The former ZANU-PF candidate enjoys support in the Marsh provinces, and this participation would have made rigging in those provinces difficult. The relief granted in this matter straightened Mnangagwa's hand. Ballot Cove. 24 cases were brought seeking to bar the Ballot Cove from contesting in the High Court. The applications were granted on bogus grounds. What is even more illuminating is that the applicants or ZANU-PF activists relied on documents that the CCC had no access to and which they could only have been given by Zeg. Double candidates. Judy lodged nomination papers on behalf of certain individuals in order to create double candidates. The double candidates plainly admitted that they had not paid nomination fees and were accordingly not involved in the process of their nomination. Indeed, when a challenge was brought, FAS procured for all of them legal representation by a single firm of legal practitioners. Although their nomination had nothing to do with the CCC, upon a suit being brought by the CCC seeking a declaration that they were not its candidates, one of the Electoral Court judges who has a complaint pending against him heard the matter and dismissed the application. An appeal was lodged, but the Supreme Court flatly refused to hear it and even rejected heads of argument that had been filed by the CCC. Certainly, there were double candidates during the elections to the prejudice of the CCC. Final voters' roll case. The voters' roll given to candidates had discrepancies with the list of polling stations issued, which made it clear that this was not the voters' roll that was going to be used during the elections. This matter was placed before the same judge who had the first voters' roll case, and he once again, as he had done with the first one, dismissed it. Observers. Certain local observers were barred from exercising their functions on bogus grounds. A challenge brought by them was unsuccessful through the action taken against them was both unlawful and unprecedented. The rallies. The CCC had more than 110 rallies barred in the run-up to the elections. Challenges brought against these bars failed. In certain instances, courts would set down the challenges on dates that were after the scheduled rallies. This was particularly the case in Bindura, where CCC was meant to have its election launch rally. Beldi now. In Seke constituency, CCC members, including a chief election agent for a candidate, were assaulted by ZANU-PF officials. When they sought sanctuary from the police, they were promptly arrested and denied bail. They continued in custody. On the other hand, ZANU-PF officials who made a CCC supporter lawfully going about his own business in Glenview were all admitted to bail. Cheza, a losing CCC candidate who now lost to a candidate responsible for the disappearance of a police officer who had refused to be used by ZANU-PF, is himself in custody over a flimsy complaint, having been arrested a couple of days after the elections. Ballot papers case. Contrary to its statutory obligation, ZEC did not advise political parties of the details relating to the printing of ballots, their number, and related issues. When it was taken to court, it undertook to unveil those details by the 19th of August 2023. It then purported to give such details on the 18th instant but refused to provide the serial numbers. Elections were held before this matter was finalized, and it is now known that while ZEC claimed to have printed ballot papers, there were no such ballots in all opposition strongholds on voting day. Inauguration. To crown this, the Chief Justice is officiated at the inauguration ceremony before the period set by law for a challenge to the presidential election has elapsed. All these cases demonstrate a pattern or two perceptible and which it would be ill-advised for the CCC to ignore. Of the 7 judges in the constitutional, 2 of them sat in the MDC matter, which led to the eventual enforced formation of the CCC. Although the MDC had held its elective congress, these judges held that the interest of democracy, it had to go back to its 2016 structures. The idea was to remove Chamisa as the leader of the MDC in Mnangagwa in the 2018 elections. What is largely of concern is that this unacceptable judgment was handed down when the country was under a complete lockdown. Courts were closed but were only opened for purposes of handing down that judgment. This was a deliberate move meant to ensure that no protest would attend upon the handing down of the judgment. The judges had this for a consideration and were prepared to break the law in order to contain a reaction cannot be got over. These circumstances show that these judges are unfavorably disposed against the opposition in general and Chamisa in particular. The judges who must hear any petition in the year 2023 are the very same judges who sat in 2018 and produced a controversial judgment in favor of Mnangagwa, which has been criticized by academics and judges alike. The Supreme Court of Malawi emphatically refused to follow the judgment, which has received worldwide condemnation. There's no chance that these judges could dispense any justice this time around. Apart from being naturally beholden to Mnangagwa, the Constitutional Court judges, just like all other judges, are routinely threatened by the Mnangagwa regime. The statement issued by the Minister of Justice is a case in point. It is of significance that even SADC has itself received threats from the Mnangagwa regime. This matters is the fact that Zimbabwe is a securocrat state. SADC has its own report probably noted that the legal playing field is not even and that the judiciary is fully captured. This has been the case with reports by other missions. For these reasons, the Citizens Coalition for Change could not expect an impartial hearing from Zimbabwean courts. For that reason, there are no domestic remedies available to address the electoral malpractices that severely undermined the freeness and fairness of the August 23 elections. So guys, that's the latest here. And wataura zvakawanda, I mean, lot of stuff panyaya dzemajudges, panyaya dzemitemo, panyaya dzakasiyana-siyana. And I'm so glad that they even mentioned nyaya yaDouglas Munzura yavakareiza before my elections, nyaya yedelimitation report. I mean, vachamisa vakaseka vaDouglas Munzura, but I mean, you could have actually joined panyaya iyoyo and because inyaya get very very serious and tikadai tisama problems akadai so because munzu rangoona zvanga zvakaipa pareport yakaburwa nezek here before my elections. But anyway, we'll be keeping you guys up to date with the latest here. Do you agree with Wachamisa or not? Do you agree with Triple C saying kuti aitaana kukoti hapana chaingobuda the same results akabuda muna 2018 because the same judges who said muna 2018 the same judges who are also constitutional court muna 2023 because their time was extended. Remember Malaba akapuwa dzimwe 5 years. He was supposed to retire at 70, but he was given another 5 years, which is until he is 75, then he can retire. Yeah, and he was also given $400,000 beginning of August as a bonus. Yeah, direct from Mnangagwa himself, the president. I mean, lucky Malaba. But anyway, weekly news roundup. Thank you for listening and watching. Bless up.